Thank you for joining us for this session where we are going to attempt to say things that no one has already said about class actions by focusing specifically on how litigation has been evolving in the last year or so against technology businesses. I'm joined today by Pedro from Portugal and John and Yana from the US. We are a nicely balanced panel. Pedro and I both focus on the defense side of things. John and Yana very much on the claimant side of things. So hopefully you're going to get lots of different perspectives today. I just thought I'd spend a minute setting the scene before we dive into the questions for the panel. So I spoke last year on the same panel. A question we got was, did we expect things to slow down against big tech in the next 12 months? I answered no. Guess what? I told you so. We've heard really why class actions are continuing to evolve generally. A few trends I just wanted to note specifically against big tech to set the scene. Subject matter, what are we seeing right now? Lots of privacy cases, they're not going away. There's a lot of focus, particularly on the use of personal data in ad tech in relation to tech cases at the moment. Competition is a massive growth area in the UK, as we just heard, but also in other jurisdictions. I know Pedro will talk about that. And we're starting to see cases focused more on the online safety world. So cases popping up across Europe focused on addictive design, dark patterns. I think we will start to see similar cases in the UK in due course. I'm not going to give anyone in the room any ideas about how those might be framed, but I think that that is very likely. Class actions are spreading. A couple of years ago, I was at this conference, and really people were only talking about the Netherlands, the UK, a little bit Portugal, which was the new kid on the block at the time and is definitely not anymore. In the last 12 months, we're seeing a lot more cases popping up in Germany, Denmark, in Belgium. We heard Rita mention earlier the evolving scene in Spain, and there are some other countries who I understand have gone for an opt-out system under the RAD, Sweden, Slovenia. So it's not a case now for tech companies to be battling one piece of litigation in one jurisdiction, but actually it's a real challenge to have those fights on multiple fronts. Litigation is arguably overtaking regulation, especially in this deregulatory environment that we seem to be in at the moment. We're seeing consumer associations who've almost rewritten their identities to drive forward their agendas, perhaps feeling that, regulatory delay or inaction is somewhat of a frustration for them. I noticed on the ICCL's website, their raison d'etre, their mission statement is we advocate, we investigate, and we litigate. And I heard the new head of NORD making comments recently about all of the potential that she sees for collective redress as a new avenue for change. And whilst they're kind enough not to leave any of the tech companies out, we're also seeing, I think, them finding their favorites. So we've seen NOIB for a long time really focused on Meta's privacy practices in particular. We're starting to see SOMI, I think, really focusing on TikTok in multiple jurisdictions. So I think that's also an emerging trend that we are seeing and will probably continue. And because of the nature of those associations which are behind these actions, it's not all about the money. They're actually demanding change. And that can be as much of a headache, if not more, for tech companies than actually the thought of having to pay out massive amounts of money. So end the pay or OK consent model. Discontinue your training of AI models using data allegedly without lawful grounds. I will stop there, and I think let's dive into some questions, but hopefully that has set the scene a little bit. So, Yana, if I can start with you. A question that always plays on my mind, and I'd love to hear more about this. How do you, as a claimant lawyer, identify and decide which claims you're going to bring against technology companies? What inspires you? Is it regulatory actions? Is it things that are going on elsewhere? Or is there some other means you use?
Certainly. Thank you for your question. I'd like to think that as plaintiffs' lawyers and US, we inspire the regulators. We don't wait for them to act. And frankly, if we were, it would take years just for anything to happen. Unfortunately, regulators, sometimes they have agendas that they have to pursue, and a lot of harms that are happening in the marketplace are just not addressed. What's interesting, especially in the current political climate, even some agencies like CFPB, because they're not getting enough funding, they're dismissing their actions that are meritorious. So typically in the US, because the barrier to entry is so low, any company can enter the marketplace unless it's for drugs or medical devices. It's really easy to enter. So plaintiffs' lawyers are kind of acting as regulators and investigating their claims, be it privacy, be it competition claims, anything. And the way we bring actions, it kind of varies. For instance, in privacy, like data breaches, there's a lot of competition. The news comes out, and everyone files those actions, and the question is really, who is going to be leading those cases? But what I really like is also other privacy cases that you build up to them. You work sometimes with experts to determine how that privacy is being affected. Sometimes you have to do tremendous amount of research to develop your case. I mean, we have a lot of AI-related cases that we're leading against big tech. So for instance, our Google action for copyright litigation, for taking all of the copyrighted works and training their models on those works. That's something we brought after putting hundreds of hours of research, because guess what? We don't have the access to their training data. We don't have the access to their data sets. But for us to bring a case in court, we have to have enough and show the court that we've got the goods. So I think earlier David was talking about the barrier to even file the action. We still have to deal with that, even though it's Rule 8, sometimes Rule 8, sometimes Rule 9. But the point is, we have to investigate and we have to show the connection. Like I said, in our Google action, where we're able to show that the copyright works are being trained on by connecting to certain pirate websites and showing that those pirate websites were scraping, Google was scraping the data from them. In other actions, you develop based on your working with the experts, like I said. Sometimes it could be the IT-related experts, the software-related experts. So there are a lot of inspirations, but certainly not regulators.
Thank you very much. Sounds like there's usually a bit of lead time when you're thinking about actions. Does that sound right, John?
Depends, I think. Certainly in connection with, data breach litigation, Yana mentioned the literal pile-on. Years ago, I was sitting in having breakfast, and somebody said once the internet came into existence, everybody became a class action lawyer because you could find a client. So in the data breach litigation, that's certainly true, because those are publicly announced. There's laws in the U.S. which require that they be announced. In the data privacy area, where most of my time is now spent, those cases do take a while. Recently, we culminated one of our cases against Google with an very outstanding defense firm. And that case took 5 years to get to trial. Of course, there were months before the development. It was a case involving a privacy button on cell phones and other personal devices, which allowed the operator, the owner, to request or actually opt that Google not collect their app activity on third-party apps, where those app developers used a Firebase tool, a Google tool. That resulted in a verdict of $425 million plus. Plus, we've asked the court to consider additional unjust enrichment of $2.1 billion. Again, and as well as injunctive relief being fiercely defended by an excellent law firm, her firm.
You're too kind.
in the U.S.
I can't take any of the credit.
So, the data privacy cases, the one involving the misuse of data and trying to figure out, well, how is that information being harvested? How is it being misused? Do take a much heavier lift.
All right. And Pedro, we heard Rita mention earlier that the competition courts are busying up in Portugal, and that she sees actions being brought to Portugal that mirror actions being brought elsewhere. Are they copycat actions that have started elsewhere, or is it the other way around? What kind of cases do you see? How are they coming about?
So strictly in terms of big tech, the majority are copycat decisions. As you said, precisely because they mirror arguments and pleadings and claims that were already advanced in other jurisdictions, the Netherlands, the UK, other member states. I think there are two exceptions in Portugal. So one exception has to do with consumer regulatory mechanisms that we have put in place. I think the biggest example is the so-called electronic complaints book, which is a very national mechanism pre-DSA, so even before the complaints mechanisms under the DSA. And in our view, of course, the imposition of that mechanism was against the country of origin principle. But that was an example where Portugal was a first mover. And I also think that in terms of scrutinizing unfair terms, we're also a first mover. But essentially copycat decisions. But I have to say, I don't like that expression, sorry to tell you that, because I think each case is a case. Once you have a case in a national jurisdiction, it has its own life, obviously. The value of parallel actions, obviously, for big tech companies lie in, of course, promoting and maximizing exposure, coverage, putting pressure on settlement. So this is probably an area where a parallel action can be potentially more threatening to a company. The fact that Portugal is a jurisdiction, although claimant friendly, doesn't have early merit filters, which means that the cases will take time, are taking time, which increases the pressure effect on companies. So don't really like that the copycat expression, but yeah.
No, I can see that. And as we heard in the European session earlier, it's the perfect example of how it can play out differently in different jurisdictions,
Yeah,
right? You can settle it in a million countries, but Portugal's going to fight. Looking more towards what we think might be coming down the line, John, what subject matter do you think will feature in class actions against big tech in the US in the next year or so?
So certainly the misuse of information. I think until there are more results of the type that we obtained in August and September of this year, companies are going to still figure out ways of collecting and harvesting information. I think some of you who've heard me talk before have heard the expression that information is the new oil. Google actually calls it the new gold. And it now drives a lot of economic economies. The biggest companies on the face of the earth don't make anything. They harvest information and they use it, monetize it, and most of the largest cases that I have now are data misuse cases, whether it be Meta, several against Google that have still pending, Twitter, now X, and then some other smaller companies. And one of the things that, at least in the data breach litigation, that I have found is a question when I pose to the other side, why are you keeping this information? There was a large breach of medical information of a medical facility, and they had social security numbers, which in the US is the key to unlock all kinds of financial transactions. And the first call I got from the other side was, well, can we destroy that? And my question was, why are you keeping it? So, there are some companies who harvest information and they don't know why they're harvesting it, or they're putting it into a bank until they can figure out how can we monetize it. And then there are other companies, as I mentioned earlier, that are harvesting it. Yana's firm, is on some of the cutting edge in the use of litigation against companies that are building AI without ever asking permission. And then sometimes the permission of companies with respect to harvesting and use of information is buried pretty deep, and it's a question of whether or not the consumer could, one, ever find it or understand it if they found the disclosures. And certainly that issue was at the forefront of our Firebase litigation against Google that went to trial and verdict this year.
Thank you very much. You've teed up perfectly a question. But Yana, do you want to follow on from that first?
Yeah, and I actually agree. I agree with John that we certainly will see we'll see a lot of misuse cases, but also with AI getting into every industry, and we have some cases for faulty AI use, because you have, especially in industries like healthcare, insurance, you're seeing already mass denials of claims based on AI. It takes 2 seconds to press the button, right? And there's mass denials of valid claims where sometimes elderly are not getting the extended care they very much need and have recommendations from doctors. So there will be more cases, I think, in that realm too, in banking industry, healthcare industry, because of that integration, anything related to claims. But also I was thinking about recently there have been so many more cases, because I'm sure you've heard of related to different LLM models and their use, encouraging suicide, for instance, and things like that. They're very righteous cases and very touching. And the worst part is that AI is still unregulated and it enters everywhere. I'm not sure how it is in the EU, but in US, schools use a lot of iPads, and they're requiring kids using iPads. They're requiring kids using different technology. All of the technology has AI at this point. So your kids, whether it's using toys that have AI or now using schools' devices, they're going to be exposed to AI in one way or the other. So not only their data is being taken, but also what I'm very fearful of, manipulation that it's going to come in with that as well.
Just 2 things to follow up. We're dealing with technology that's emerging and being used in many ways, as Yana mentioned, in claims handling, not just in the medical arts, but also in automobile insurance, vehicle collisions, repairs. And at least in the US, the regulatory regime has not developed fast enough to catch up with the technology, because a lot of the legislatures who are trying to figure it out can't catch up fast enough to how these things are being developed and implemented. And Yana talked about the harvesting of children's information, where certainly children are not consent. They're not capable under the law of consenting. And we have litigation against some educational companies where the school districts may have consented to the harvesting of information of children using certain products. Well, that's not good enough. And we'll see how that litigation develops, but I think you're going to see, again, courts and certainly governments pushing back against AI. I'm not sure about this administration in the US, but maybe the next administration.
Mm-hmm. Thank you. And Pedro, what subject matter are you seeing against big tech in Portugal? Is AI a feature? What do you think is coming down the line there? And actually in other EU member states
not
too.
AI yet. I mean, I see clear convergence, between Portugal and other member states, but with different speeds. I mean, what I see in terms of big tech is that plaintiffs are pursuing compensation for allegedly unlawful data processing activities, tracking, profiling, challenging consent practices, cookies practices, real-time bidding, or legal basis for targeted advertising, online, of course, online safety issues as well. I have to say that I think we're in the middle of a national European conversation about the use of technology and about safety. That doesn't necessarily needs to be judicialized, in my judgment. So it's a biggest conversation. I'm not excluding courts, of course, of being part of that conversation, but it's actually a social and national conversation. And I think the more you judicialize these conversations, doesn't necessarily mean that you will have a good outcome of it. So that's on the data protection field. Then on the consumer protection field, as you were also mentioning, issues around design, marketplace design, default settings, auto renewals, cancellation, frictions, the subscription economy, the whole subscription economy, subscription practices. I see as well that area as a very prominent area for class actions. No data breaches class actions in Portugal so far. Strangely, no data breaches. So eventually we'll have one or two soon.
Is that because you don't have associations that focus on that as an area?
I know. We have members here of associations. They can answer that question. But I think we have now transposed the NIS2, so the Cybersecurity Directive. Companies are still adjusting to it. Probably there's the sense that we are still adjusting. But we had a couple of major cyber attacks in the last years that could have evolved into litigation, but we didn't. That's the only area in my country where I don't see the same path of Canada or the US, for example. But the other areas are, the other subject matters are relatively the same.
Interesting. Thank you. John and Yana, how does litigating against a big tech business differ from litigating against other businesses, if it does? What do you change about your approach?
So I think for some companies, and I'll take the stick out and beat Google up again, Google doesn't act like normal companies because it makes so much money. And that's true of some other big tech companies like Meta and Twitter now, X. Most, and I'll be careful here, but most companies that I litigate would rather get back to making widgets or whatever their product is, or, they're not in the business of litigating. And I see on those companies' perspective, thinking, how do we reduce risk? And usually that's through resolution after perhaps testing the case itself on motion practice. Big tech companies don't do that. They have a different vision. I don't know why. Maybe it's because they make so much money that they feel immune. I mean, ultimately, Google, for instance, has taken a pretty severe beating, both in antitrust cases. I was talking to Jeremy Lieberman, who will speak next, about his litigation in the securities realm. In the data privacy, aside from our verdict, there was another one in state court called Supo, where Google was hit for $313 million. That's a rounding error for them. So that's a difference that I see. And thankfully, I have a big enough firm with 1,200 lawyers that only do contingency fee litigation that we can match whatever they want to throw at us. But that's a big difference that I see, the way they approach litigation and risk. And decades ago, and thankfully have a younger picture of me, thank you, I represented insurance companies or their insureds. And dealing at the C-suite of those companies, and certainly companies like CNA and Chubb, they always looked at minimizing risk without having to outlay cash through, a spin of the jury wheel, so to speak. Big tech doesn't act like that. My observations, at least.
To throw an insight in there, I suppose one of the differences between, say, a tech company and a company that makes your widgets is they tend not to be, as we said at the beginning, tend not to be fighting the battle just in that one courtroom or in that one state. And it always astonishes me at the outset of defending a case to unpick all the other proceedings, whether they're regulatory or civil, that are likely to be impacted by the arguments you'll be running in your one specific courtroom. It's not just the parallel cases with the same subject matter, but those cross-cutting issues that can, really be affected by exactly the outcome of this one.
I think that's totally accurate.
Right. So there's a lot more at stake.
Yes, there's a lot more at stake, and then some of the things that we're doing could affect the way they engage in business. Mm-hmm. Other than, having to repair a defective automobile that has a part that's broken in 1,000 cars, mm-hmm. It can affect their business. Mm-hmm. You're right.
Mm-hmm. And Pedro, maybe just building on from that, how do you assist your tech clients in considering that bigger picture when you're defending a Portuguese class action? Thinking about those knock-on effects, what's the different approach you take?
That's a great question. First, Portuguese actions are just one node, right? Obviously, in a multi-front strategy involving many sorts of decisions, public enforcement, investigation, etc. So, I think the first step one needs to do is to map the exposure, right? To manage cross-border exposure, understand, which parallel actions are actually taking place, in both public and private, regulatory decisions, etc. So the first thing is obviously to map. The second thing is obviously to keep consistency. On the facts, on the narratives, on the legal arguments. That consistency has obviously to operate also cross-border. Then, there are other, I think, potential relevant tools to manage these type of, cross-border claims. So, paying close attention to potential downstream effects, so, disclosure rules, for example, the effects of disclosure in other countries. Manage, I would say as well, public enforcement strategically, if that's the case. Because obviously plaintiffs are very attentive to follow-on risks. Public decisions can be cited as also with a certain interpretive effect. The GDPR, the one-stop shop mechanism, is also very relevant and can be used strategically when you have parallel actions. One conducted by a public regulatory actions when you have one conducted by a leading data protection authority. So this is something that you can also manage strategically. And I think the final idea here is of course, to ensure coordination. And one thing our clients ask us occasionally to do is to also help them to align messages, also product messages, also messages on how a certain product is described, how a certain or product safety message is described, even aligning with product safety teams or pricing teams to ensure that there's full coordination and that there's any risk of adverse inferences, or messages that are somewhere and probably no one had a look at those messages, but those messages can be a problem. So I would think of a strategy, basically composed of all these steps to ensure that, with the fundamental goal of minimizing cross-border exposure and avoiding risk. Although of course, each case, the Portuguese case, Portuguese proceedings can be used, of course, also to contain risk, but we can also use the Portuguese proceedings as a broader resolution plan. I mean, it depends obviously on the case.
Mm-hmm. Yeah, I mean, I would add to that. I would say this because I've got clients in the room, but it is a delight actually to work on these cases for these companies, because unlike with a lot of clients where litigation lands and it's reactive and you're figuring out what the story is as you're kind of going along, these clients consider litigation risk management from the moment something like a new compliance program lands, right? It's all part of what is the narrative going to be on this issue, what are the stances we're going to take, and so you're usually benefiting from some very deep, careful thinking that's gone on for years in advance of whatever risk ultimately emerges.
Agree with you.
Yana, flipping over to the economics of class actions. So in the US, against big tech, from the claimant perspective, what are the main cost inflection points and factors you're taking into account when you're running proceedings? Is there an optimal point in time which you want to achieve a big win or a settlement? And I know it's difficult to generalize, but can you talk us through some of the thinking there?
Sure. So of course, there's not, as you pointed out, there's not like one size fits all. You have to really gauge your case, and of course, the value of the case goes up as closer to the trial you get, right? Because your risks are going down. Of course, there's significant risks associated with every stage of litigation, but as you proceed, first battle, motion to dismiss, you proceed. Second battle, class action, class certification. Let's say you win that. Obviously, the case value is going to go up because your risks are going down. The hard part is that when you're dealing with big tech, very often you might want to try to resolve it early, but you might not be able to, right? Because one, you don't, even though the risks are there, the value of the case is so tremendous that big tech will want to invest the resources to at least test this case out until the class certification or motion for summary judgment. And guess what? Even at those stages, even if they prevail, if you prevail, they can appeal and they can try to drag it out, right? So I think all of those things come into play, but I would say in cases like data breaches, very often you see resolutions earlier on, after a motion to dismiss or even before a motion to dismiss. It kind of varies, but I would say in most other claims against big tech, for the majority part, the resolution would be after the class certification or after the motion for summary judgment. Of course, there are different ways to see. Again, the value is different, and it doesn't apply to all, but that's at least what we often see based on, like, the larger the cases, you're probably going to have to be prepared to go to trial or at least survive through all those stages.
Thank you. That's really interesting. And sticking on the theme, I suppose, of the conclusion of the case, John, in Europe, in privacy cases, the judicial approach to measuring damages, it's not quite finger in the air maths, but it's not far off. Kind of look at historical case law, hit upon a figure that claimants think they might persuade a judge is reasonable for kind of low-level distress type claim, and then kind of run with that. Is there a more scientific approach in the US in privacy claims? I know there's some statutes with set tariffs, but beyond that, how do you go about kind of quantifying damages in these claims?
Yeah, I've spoken about this before at other conferences. In the U.S., we're extremely litigious. Most disputes, rather than end with a handshake, are taken into court. And as a result of that, through our data privacy litigation, we're constantly trying to refine that block and make it into a round wheel. At bottom, one of the damage models that we use are nominal damages, the concept that originates in Roman law, where for every wrong there's a remedy. Those damages tend to be inconsequential, and I think based upon the economic calculation that I made, where nominal damages were first quantified in England, it's about $16 in the U.S. We're in those states where nominal damages are $1. In states like Virginia, which is a very conservative state, it's $100. In the state of Georgia, it's whatever the jury wants to decide, but not $1 million, because that case just went to the Georgia Supreme Court. That's at bottom. One of the other types of damage models that we've certified and was upheld at the 11th Circuit was loss of time. In responding to a data breach, people took time to mitigate their damages or to protect themselves. I'm not a fan of that one. Please don't let this get back into a brief, but I think there's some challenges unless the courts adopt the manual for complex litigation, which has some ways of resolving damages on a class-wide basis. Dark web prices, or now what we know to be in the free market of data brokers, the value of information. So if in a data breach context, if information is taken, data brokers now have valued each element of our information, and you can ask a jury for that information. In a data misuse case, it's one that I think is has a solid foundation is unjust enrichment, or the amount of money that not the value of what a plaintiff lost, but what the defendant gained from the misuse of that information. What I think even in the UK they call unjust enrichment. And as I mentioned, we've asked the court in the Google litigation, separate and apart from the verdict for damages, to award unjust enrichment of $2.1 billion. One of my favorite in the data breach context is a model based upon the cost of an identity theft product. Typically in the U.S., in the wake of a data breach, companies offer a form of credit monitoring or identity theft protection, but it's only for a period of a year or two, tops 3 years. The problem is that information continues to be accessible and usable by an identity thief to cause damages for, depending upon the data elements, the lifetime of the individual. So we have I think Jerry Thompson's here from SciEx. They have an excellent product, among others, out there. So what we do is we use an expert who is formerly of law enforcement, the Federal Bureau of Investigation. Before I used Kevin Mitnick, who some of you may know is the most celebrated hacker ever known on the face of the earth, who unfortunately is deceased. And we use this ex-FBI agent to talk about how information can be misused, and that one of the ways in which consumers can be protected is through the purchase of an identity theft product. So we take what that value is among different products, and we then take an actuary if we have dates of birth. If we don't, we can still do it. And we model a damage model for the class, whether it be 98 million that we had in Capital One, or a smaller class of 170,000 that we have in a company called Americold. And we'll take that annual cost and we'll spread it out over the lifetime of the consumer, and then back it down with a present day value or discount rate. Now, you could take that same model and say what the cost would be for 5 years, 10 years, and 20 years. And that's the sum of money that we would ask the jury to award. To date, no court has certified that because every time we get close to taking a case to certification, we settle it. The one difference would be a case, Celion, that's in this Northern District of California, where the judge struck on a Daubert challenge the accountant that they used to support part of the theory, which was a misstep, but he still indicated that that would be a viable theory. If that's certified, I think you're going to see a lot more traction for that in the U.S. In Capital One, and again, the damages could be pretty extreme. We had 98 million people, a lot of Epic, number of people sitting here were the administrators for that. But when I was arguing for damages before Judge Tringa, the trial judge who had to decide class certification, the amount of damages for a lifetime was $500 billion. The response from Capital One's lawyers to the court was, well, Mr. Yanchunis wants more than Capital One is worth, and which I responded, well, Your Honor, if I was here arguing for one plaintiff and the damage was $10,000, would that be a problem for anybody? Of course not. The fact there's 98 million people, it's not my fault. That's Capital One's fault. Now, we settled that case for $190 million, but still, that is a viable theory that I think would have traction here in the EU, and I know that SciEx, I believe, has that product in the EU. And for a data breach, I think a court could wrap their arms around that and certify it.
Very interesting. Let's hope not.
I'm happy to share that with anybody in greater detail after this conference.
And the unjust enrichment point, I think, is a very interesting one, because so far the High Court here, at least, hasn't really liked that in data misuse cases, but it doesn't feel to me like that's the end of the road here either. Conscious of time, we should probably wrap up. Pedro, I'll come to you if I can. The Rep Action Directive was intended to have safeguards built into it to protect it against abusive litigation, of which some might say big tech are often the target. I'm laughing because this now feels like such a loaded question from defense lawyer to defense lawyer, but in your experience defending cases against big tech in Portugal, would you say that these safeguards are working?
So the Portuguese system is much more than the RAD directive, because our framework goes back to 1995. And actually before the RAD directive, I would say that the filters are very weak, the safeguards are very weak. Just to give you the example of that case I was mentioning, the various cases about the adoption of the electronic complaints book, where we had settlements, early dismissal decisions on the merits, so very different decisions for the same case in what seemed to me a very straightforward case. And if we had, of course, better procedural filters, we could have responded to those cases in a different way. With the RAD directive, as you are correctly saying, we now have more safeguards. And I think there's more activity in terms of controlling or assessing standing or representativeness. And we have already a recent situation where one entity has been disqualified as a cross-border entity. So I think I see from not necessarily from the court's perspective, but also from the public administration perspective, more activity. But I still think that the results are a bit erratic. I still think that the safeguards really need to be translated into more case-specific controls. My personal view, this is absolutely personal, is that the Portuguese law of 1995 should be amended, to be quite honest, that those procedural filters that those filters, those early filters, assessing the commonality, assessing the class scope, etc. These type of topics should be part of that early filter system. You can call it a certification phase, or but we should probably consider that as well, because my view is that safeguards are still weak and are still erratic. The thresholds are still are still low, in my personal view. Occasionally, we look at, even doctrinal constructions. So, for example, the Germans speak of the principle of procedural responsibility, and they claim that each plaintiff has a procedural responsibility to represent the class in an appropriate way. So if you are a plaintiff and you fail to represent the class in an appropriate way, you are not complying with the principle of responsibility. This is, of course, a doctrinal tool, a doctrinal principle. But this is the sort of and I'm conscious that
It's
the clock,
flashing
and
aggressively at us.
this
Puts the
thing
clock
is
down.
this thing is actually a warning that it's so you can't just escape this. But my view is that those safeguards, and we have now with the RAD directive I think the momentum to be more sophisticated or more demanding in terms of the safeguards, because the RAD directive actually opens the door to that. Yeah, thanks.
Thank you, that was great. I don't know if we have time for questions, looking at the clock. I don't know if there are any, but I'll offer that up to the room otherwise. Thank you all very much. I have learnt a lot. I hope everyone else has too.
Thank you.
Thank you.